We spend months meticulously drafting wills to protect our homes and bank accounts, yet we frequently leave our entire digital lives locked behind passcodes, completely inaccessible to those we leave behind. This chart shows the scale of our modern footprint. The average person under 70 now maintains over 160 digital accounts, ranging from investment portfolios and photo libraries to daily household utilities. Without a plan, these accounts survive your death only to enter a permanent state of legal purgatory. This happens because of the Computer Fraud and Abuse Act. It's a federal anti-hacking law that criminalizes unauthorized access to computer systems, and it applies even after a user passes away. Tech companies use these laws to enforce their terms of service. If a grieving family member tries to log in to retrieve photos or close a subscription, the law treats them as an unauthorized hacker. Solving this requires a choice: low-effort native tech settings or high-maintenance digital vaults. Our goal is to build a digital estate blueprint that cuts through marketing claims and identifies the specific tools that actually fit your life and your family's needs. Before you choose any software, you need a legal foundation. That starts with establishing explicit consent for your executor. The governing framework for this is the Revised Uniform Fiduciary Access to Digital Assets Act, or RUFADAA. Many people assume a standard will or power of attorney automatically covers their digital life. In reality, these documents are useless for digital assets unless they contain specific RUFADAA language. This diagram illustrates the interaction between consent and platform rules. RUFADAA language specifically overrides a tech company's default terms of service, providing the only legal mechanism for an executor to intervene. However, RUFADAA has a strict limit. It is purely an administrative right. It forces companies to recognize your executor, but it won't organize your passwords or package your files for them. RUFADAA is a mandatory legal base layer, but it must be paired with software tools to be practically useful for a family during a crisis. We can divide the available software into 3 distinct tiers, scaling by cost, effort, and how much of your life they actually cover. Tier 1 consists of native tools like Apple's Legacy Contact and Google's Inactive Account Manager. These are free and take about 15 minutes to configure. This matrix shows the trade-off. Tier 1 is easy to set up and provides access to emails and photos, but it creates massive blind spots by ignoring your banking, crypto, and apps outside that specific ecosystem. Tier 2 hybrid password managers capture daily browsing habits, allowing a legacy contact to request access. But notice the warning icon. Many enforce a mandatory 30-day waiting period before entry. That delay can paralyze families trying to settle immediate medical or funeral bills. Tier 3 includes premium digital vaults like GoodTrust or Everplans. These offer secure document storage, item-by-item permissions, and timed messages delivered after you pass. Costing up to $80 annually with hours of data entry, the primary risk here is the maintenance burden. The high friction of manual updates causes users to abandon these platforms, leaving families with dangerously out-of-date data. As comprehensiveness increases, the administrative work required to keep the data accurate skyrockets. You have to choose the tool you will actually commit to updating. Let's match your specific profile to the correct tier to ensure you aren't overpaying for a system you won't use. If you are a caregiver managing an estate for a resistant aging parent, follow this first branch. Skip the premium vaults and stick to the 1-hour plan. Update their legal documents with RUFADAA language and set up Tier 1 native tools. If you want daily convenience and baseline protection for yourself, look at the second branch. A Tier 2 password manager captures your active logins without requiring a massive initial time investment. For those with complex assets like cryptocurrency or specific trust instructions, follow the final branch. A Tier 3 premium vault provides the granular control needed for these high-value items. Selecting the tier that fits your actual habits prevents you from wasting money on a platform that will eventually be ignored. Before you finish your plan, there is one critical security mistake frequently found in traditional estate planning. Never write your master passwords or PIN codes directly into a physical will. Once a will enters the probate process, it becomes a public record. Any sensitive passwords written inside it are accessible to anyone who looks up the core file. Remember the golden rule: software alone cannot bypass federal law. RUFADAA language in your legal documents is absolutely non-negotiable. Spending 1 hour today aligning your legal documents with a specific software tier removes the administrative burden from your family, allowing them to manage your accounts in days rather than years.